This video will be covering the facts and findings in the case of the Australian Video Retailers Association, or AVRA, and Warner Home Video Proprietary Limited, which was heard before the Federal Court of Australia in 2001. AVRA commenced proceedings against Warner Home Video for allegedly making unjustified claims for infringement of copyright, and that such claims contravened Section 52 of the Trade Practices Act by engaging in conduct in trade or commerce that is misleading or deceptive. Warner Home Video sought declarations that copyright for certain DVD discs purchased and commercially rented out by AVRA would be infringed by a person whom, without the consent of Warner, rents and plays them. Pursuant to 029 of the Federal Court rules, both parties formulated preliminary questions that were paramount to the case. These questions related to two discs, the Bait DVD disc and the Romeo Must Die DVD disc. The first question was, does a person who plays the discs make a copy of the whole or a substantial part of the embodied film? Under Section 10 of the Copyright Act, copy in relation to a film means an article or thing in which the visual images or sounds comprising the film are embodied. Section 14 provides that a substantial part of the disc must be copied. The essential test implied by the court regarded a question of substantiality as well as an inquiry into the purpose of the copying. It was determined that the embodiment of volatile, tiny fractions of visual images and sounds that comprise a film sequentially does not constitute a copy. The second question was, what computer programs are embodied in the DVD discs? By reference to professional evidence, it was determined that the material on the DVD discs in question that constituted computer programs were limited to program instructions and did not extend to the audio, visual, and caption content of the discs. The third question was, when a video store proprietor enters into a commercial arrangement with the discs, does any of the computer programs constitute the essential object of the rental arrangement? The court determined that the essential object in this case was to obtain the capacity and right to experience the motion picture in both its video and audio aspects. The final question was, does a person who plays the discs copy in a material form the whole or a substantial part of the computer programs? The court had to consider the meaning of material form, which is defined by Section 10 of the Copyright Act, which provides that there will be a reproduction in a material form. The reproduction is in a form of storage from which a computer program or a substantial part of the computer program can be reproduced. It was determined that in the ordinary course, temporary storage of a substantial part of the computer program in the DVD player will not involve a reproduction of the computer program in a material form. In effect, by answering the four questions, the claims of copyright infringement by Warner were rejected on the grounds that there was no substantial reproduction of the content or computer programs embodied in the discs when they were played. The court requested for proposed orders pursuant to 029 to give further consideration to the conduct of the proceedings.